ज्योत्सना मैम जुड़ चुकी हैं, मैं उनको इनवाइट करूंगा कि जो आज का थीम है उस पर अपनी बात रखें।
Honorable Mr. Justice Dixit, Professor Apurvanand, Shri Nadim Khan, Shri Prashant Dayal, Shri Ikram, Shri Madam Ram Rakhiani, Learned Advocate Mr. Shamsad Pathan, and all office bearers and members of the Association for Protection of Civil Rights. The NGO institution proves that they are out to protect and to uphold legal rights, civil rights more particularly, by ensuring access to justice. And today's subject is also that way very impressive. When we say that the access of justice must be ensured by upholding legal right, we must accept that we must have equality, we must have gender justice, we must have similar kind of way of judging people or similar kind of way of appreciating ability of the people. Today, in many countries, there are 35% lady judges. But the position of our Indian High Courts is there are maximum 13% of judges, and in the Supreme Court there are 4% of lady judges. If we look at the history from 1922, the lady advocates had to initiate filing writ petition just to get a right to be enrolled as a lawyer. Even that right was denied, and the denial of the right was only on the ground that the applicant is a woman. So the first thing is that we need to open our eyes and we must do everything to fight against the ongoing gender injustice which is continuously ongoing. It is good to teach, to write, or to discuss on human rights. But when we examine the implementation of human rights, it is too poor. It cannot be forgotten that the aim of UDHR was just society. And for that, UDHR has provided that all human beings are born free and equal in dignity. Now this freedom to all on the planet and equality in dignity, is it being maintained? The answer given by Amnesty International's report is in negative. In most of the countries of the world, violation of human rights has become very common. The issue of fair trial is being questioned marked. Many of the countries and many kind of people, particularly those who are marginalized, face the biggest vice of justice delivery system, that is lack of fair trial. The physical violence is today very common. Physical violence to the person who is not of the same religion or who is not of the same creed of the religion which the attacker profess. So different faith we are not able to digest. What kind of society are we talking of? Where some person is only killed because of the reason that somebody has believed that he has flash of power or he has this or that. Now, if we think in this way, if we doubt in this way, there will be all around chaos, which is now spreading slowly. We need to immediately regulate and control these kind of events or these kind of offenses. Now, the difficulty in mob lynching or mob injustice or mob justice, whatever name you want to give it, firstly it becomes media trial. And once it becomes media trial, it becomes perception of the reporter who is reporting. So that to some extent becomes a version which is colored with the package of bias in the mind of the author. Sometime if the journalist is rightly writing and is posing his objection against such kind of incident, that also give great message to the society. Today, anger of mob on particular person, these are all growing every day. It's now alarming situation where people have lost the culture, where everyone of different religion, maybe of different religion, maybe of different caste, maybe of different creed, is accepted with the basic dignity one possesses as a human being. That slowly and gradually we are missing. I am afraid that when RTI activists are being murdered,
when right to speak or right to express are denied, where torture on peaceful protester are being done, then we need to be awakened. Honor killing is common. Khef panchayat, that is common. Offenses against women and children are common. Offenses against particular religion people, that is common. All this raise a big question about subsistence of rule of law. We as a civilized society believe that there must be subsistence of rule of law, but that should not be on paper or the lip service. It should really go to a common man, to the last man in the society. The faith a common man should have a subsistence of rule of law. That only can assure access of justice. That only can access the faith of a common man. Honorable Mr. Justice Gawai, day before yesterday only, has talked on this, and he has said that if the poor people or if the persons whose faith in the judiciary is there, if they are not attended to, or if their faith is, their trust is eroded, then there is a great danger to the rule of law. That's what the spirit of the lecture given by Honorable Mr. Justice Gawai. He has expressed his worry for the situation where a common man would lose the confidence in rule of law. In I of my own, I say in justice delivery system, because justice delivery system owes an obligation. Now, when I say justice delivery system, it is not only judge. It is judge, lawyer, law teachers, and many of them are there. Now, what does it mean? If we look to criminal justice delivery system, it is mainly to decide right norms of the person who is being tried. Whether his conduct was right. If his conduct was right, he can either be acquitted or can get benefit of doubt if it is properly proved. But this aspect that that person can be given benefit of doubt will have to again filter from the norms of the conduct. If entire penal law is seen, it would only communicate that how the conduct should be. And if some person has acted otherwise, obviously there is provision for punishment. So I was saying that who owe biggest responsibility? Justice delivery system, it has direct connection with judges. It has direct connection with the lawyers. It has direct connection with the witnesses. It has direct connection with litigant. Now, I was also worrying this morning for the witnesses, including victims. Now, are they entitled to get proper, sufficient, and friendly atmosphere in the court of law? If this is a question and if this research is done, in many cases, they do not get such atmosphere. So when they do not get such atmosphere, obviously, they would afraid of telling what they have suffered, or they cannot ventilate their agonies, their traumas. And if that is not ventilated properly, the job of the judge of search of truth will be in danger. So, as Bentham said, witnesses are ears and eyes of the judges. Should judge, when the witness or the victim comes to the witness box, do judge have any other duty other than administering oath to him or her? My answer in my little understanding is that judge owes duty before administration of oath. Whether the witness is feeling convenient, whether the witness gets supporting atmosphere, whether the witness is comfortable, whether the witness is ready and willing to assist the judge in the fact finding process, in what situation the witness is before coming to court, a courtroom. Has he proper waiting area? Has his dignity been protected before he stepped into witness box? Has he any difficulty? Is he facing any threat? Is he emotionally so much hurt that the judge should take care of his emotion and offer him glass of water? Or if the witness is old or due to some reason unable to stand, the judge should in a specific cases also offer chair to the witnesses, because witnesses are valued esteemed guests of the court. They come because court invite them by issuing summons. They are coming to help the court, so they should be regarded as guests. There is criticism when you act like this in the court, that if you see the victim crying, you offer the victim glass of water. You ask the victim whether she or he would like to sit or not. And if yes, necessary facilities can be extended. I remember my own experience that when you give glass of water, when you ask the Sirasadar or other officials to offer glass of water to the witness who is crying, the application comes from defense side that you are favoring the witness. This is not favoring, this is to have sensitivity to human emotions, sensitivity to agony the victim or the witness has undergone, sensitivity to his situation, attempting to sit in his chair. Now, these are all the things, according to me, are very, very important. We need to see to it that we are in a position to do all this. We are in a position to protect the human right of the witnesses, of the litigant, of the accused, everyone, because everyone is an important component of justice delivery system. I was just thinking aloud about other aspect. Now, other aspect, as we know what is judging, so I'm not saying much on it, because everyone are member of this elite audience are aware. But in my understanding, justice is to decide right norms of the conduct by applicable law, by constitutional values, equity, and spirit of international covenant. Now, the style of judging will have to be international. So, international style of judging require also to give due importance to covenant, international covenants, and that will have great guiding force. So, it's not applicable to judge, but largely to entire legal fraternity. Supreme Court has played best role, as we know, in Sheila Barse case, in Hussein Ara Khatun's case, in Francis Moulin case, and has given very landmark judgments and given great ideology, which is not required to be told to this court, to this audience, but suffice it to say that those all collectively communicate that the courts have a role of custodian and guardian of the fundamental right. I was just searching where did I wrote the quote of Justice Gavai. Justice Gavai says, and I quote, trust deficit in judiciary might push people to vigilantism and mob justice, which will erode rule of law. So when I was talking about subsistence of rule of law, yesterday only the fear express, the issue which the society is facing and the issue which is existing at present, that is also seeing to it that minority, marginalized women, children do have trust, because the trust deficit would result into erode of rule of law. Mob lynching, mob justice, this require different standard of evidence, different way to appreciate. We need to encourage the eyewitnesses. We also need to correct and train the basic perspective of our prosecutor, of our defense lawyer. So, speaking together, we are required to do many exercise to ensure that access to justice is properly given. And my last point is on legal service. As far as legal services are concerned, are we giving free and competent legal services which we need to give? Is it proper services? Is it given in a proper perspective? Next point, the last point is the victims and witnesses are still afraid, because today also they are subjected to character assassination, indecent question, insulting question, humiliating question, annoying questions. These all vices needs to be protected by a powerful, firm, and committed judge, a dedicated judge, a spirited judge, to see to it that everyone before the judge gets their right. So protection of rights of individual is the master key to access of justice. We are missing some of the aspect where victim should be treated in a particular way. That and all requires imparting of training. Sometime Section 165 Indian Evidence Act can help us, but that is not being used frequently and freely. In the same way, when the cross-examination is done, the judge has right to ask for genuine ground for the question being asked in the cross. But that is also not been freely used. Criminal Justice Board, Victim Compensation Board, or victim policies, all these are requiring relook to implement and to give and to ensure and to assure fundamental right, legal rights, and civil rights to all those who are connected with this. With this, I want to thank the APCR, particularly learned advocate Bishop Samsad Pathan. My regards and pranam to all, and I am very sorry for my disability to have not remained present physically. But I am more than glad to speak to all of you. Thank you so much.